Bam. And we are live. What's up, guys? Welcome to the stream. I'm here with the legend, Andrew Branca, self-defense attorney. One of the best in the game. He's no stranger to the show. The best. The best. You know, he's been on the show a few times. It's always an honor to have him on. And I think with today's topic, obviously it's trending news, but at the same time, it's also very important. And I think we can really take this moment to learn. And obviously, I brought in the heavy guns. I brought in the experts, so we can kind of go through here this case. But for those that don't know who you are, Andrew, I'm very familiar with you. Obviously, you have a fantastic book on self-defense, which is in the description, by the way, guys. Please get it. I put it right here in the description. And
we give it away for free, except
free.
The shipping and handling. We give the book away for free.
So, but yeah, can you introduce yourself real quick to the people? Your background?
Sure. I'm an attorney, a criminal defense attorney. My specialty, my exclusive focus is use of force law, meaning defense of yourself, defense of others, defense of property. I don't have a general practice. I don't do DWIs and stuff like that. All I do is basically when people shoot each other. And I've been doing that for 35 years. And
you're based out of Colorado, right?
Right now, I'm actually moving to Tennessee. Colorado's gone insane. Oh. So we're fleeing Colorado, the insanity here, and we're moving to a gun-friendly state, Tennessee.
Nice. So it's like Chud can hire you then, I guess. he can hire you as his attorney, because I think with something like this, man, you know, with the amount of notoriety this case is getting, and obviously the enormous amount of political pressure that's going to come from it, you need the best of the best for something like this. I don't think a public defendant, or even like, you know, a paid attorney is going to be sufficient for something like this. But what are your general thoughts?
So I don't represent clients directly. All my clients are other lawyers. So Chud would need to hire lead counsel in Tennessee, and then I would be a consultant to his lead attorney. We were talking before we went live about there's a lot of things for Chud's defense that need to happen right now, things that need to be secured right now. And most lawyers don't know this self-defense law stuff. In my 3 years of law school, we spent less than 5 minutes on self-defense law. And I would be concerned for Chud that his lawyers, no offense to them, I don't know who they are, but there's a good chance they don't know what they need to lock down right now. And that could really damage his legal defense.
Yeah. So I'll quickly summarize. So for those of you that don't know, I know some of you guys might not necessarily be on the internet like that, so I'll quickly summarize. Chud the Builder is a, you know, pretty popular social media figure that's, you know, risen in popularity, especially within the last 2 to 3 months. He's known for walking around, was it Nashville, if I'm not mistaken? Nashville.
Mostly Nashville, yep.
Nashville, live streaming, IRL streaming. He was on Kick, but he got banned from Kick. And what ends up happening is he'll talk with people. He'll use a certain racial slur. We're on YouTube. I can't necessarily say it. Whenever there's an altercation, and, you know, he says, hey, well, I'm keeping free speech alive. And obviously, this has generated lots of views, lots of clicks. It goes viral every time he's out there. You know, people... You know, it's created an enormous amount of backlash, but at the same time, it's created an enormous amount of support for him as well, because he's kind of dealing with more of an underlying culture, with an underlying problem in our culture in America with a certain demographic. I'll just keep it at that. And this is why I think he's been able to rise in popularity so much over the past several months. But obviously, we all knew at some point there was probably going to be a physical altercation that might lead to the use of deadly force. And that day came a couple of days ago where he got in an altercation with an individual. The person, we don't know, and I'll kind of go into the facts here in a little bit, and I'll let Andrew take over, but I'm kind of summarizing for you guys what happened. Got into altercation, shots were fired. We don't know, you know, all the intimate specifics. I do have a tweet here that kind of goes through it. We do know that he was live streaming at the time, and it was caught on the streaming platform that he was on, which I think is like Pump Fun, for those that don't know. It's a more obscure streaming website that utilizes tokens and crypto trading while the streamer's live. So it's not like it's like YouTube or Rumble or Kick where you can go back and watch the replay. It's a bit harder, more difficult. But that's kind of the gist of it, guys. So what we're trying to figure out here is, A, is it self-defense? B, does his provocation, you know, hurt his self-defense? And 3, what might happen from here based on what we know? So, Andrew, I'll just turn it to you, man, and you can just kind of take lead.
Yeah, I guess the first thing I'd like to say, because of course I've been talking about this on social media, and the heated, hyper-emotional responses I've been getting back are really, I think they're greater than the Zimmerman trial, than the Rittenhouse trial. People feel extremely strongly about this emotionally. Mostly white people are giving me this response. And I just want to say up front, I understand I understand the fatigue. I understand how you all feel about this. I understand that, the 5% of the population that's young black men commit 60% of the violent crime. I understand that white people are treated far harsher in the criminal justice system than many black people are. I've seen the same news stories where a guy commits a violent crime and is let out 10, 12, 15 times, and then puts a knife in the neck of a little Ukrainian girl on a train. I get it. I know how many of you were overlooked for jobs, for college, for medical school, because a less qualified person of a different ethnic group got that slot instead. I understand these are huge problems. These are enormous public policy concerns that need to be addressed. We don't live in Jim Crow anymore. I call it John Crow. It's the white people that are disadvantaged and have been my entire adult life. We put $400 billion a year, the net taxpayers in America, which generally means white people and Asian people, effectively put $400 billion a year into the black community, and it only gets worse. It never gets better. I mean, we would all have flying cars. We'd be on Mars. I mean, the life we would be living if we weren't doing this. I understand. So I just wish people would stop yelling at me about it. I get it. But that's a different matter than doing legal analysis on a use of force event. When I do legal analysis, I turn my emotions off. I become Spock. It's completely emotionless. And I can tell you and right now we're kind of in the fog of war on the facts of this Chud shooting. I'm hearing very different versions of the facts. It's hard to tell what's true. The only video I've seen is just not helpful. And there are hypothetical versions of the facts in which this is clearly lawful self-defense by Chud. But small changes in facts lead to enormously big changes in legal outcome in self-defense cases. So there are small variations in the facts here that could make this not self-defense, that could make this attempted murder. And if he's convicted of attempted murder, and there's a whole array of other felonies he's charged with, but they all follow from the attempted murder. If he's not guilty of that, they all go away. If he's guilty of that, they're all in too. But attempted murder by itself is good for 60 years. It's effectively a life sentence for a 30-year-old man if he's convicted. The case could go either way. It all depends upon how the facts work out. Chud the Builder is not a friend of mine. He's not an enemy of mine. I have no emotional commitment in this guy one way or the other. So when I do the legal analysis, please understand, he could be called John Smith as far as I'm concerned. I knew nothing about this guy until a couple days ago when this shooting happened. I don't have any animosity towards him, and I don't have any reason to lie for him. So when I do the legal analysis, just keep that in mind. Now,
do you want me to bring up
I've been talking a while.
No. I'm glad that you got that disclaimer out there that we're going to be as objective as possible in this legal analysis here. Whether you like Chud or you don't like him, we're going to be impartial and very fair here on this situation. So I do have one set of facts and circumstances here that I can bring to your attention. Me and you kind of discussed it off stream, and I'll pull it up right now for everybody. And obviously you said that you've heard different versions as well, Andrew, which I'd be, right, happy to hear the versions you've heard. And what we could kind of do for you guys, since nobody really knows the exact fact pattern, what we could do is go through all the fact patterns for you guys and give you guys a probable, a probable outcome of what would happen with each of the different fact patterns. And I think that's the best that we can do here because nobody really knows everything. So let me go ahead and share screen here. This comes from Twitter, guys. Well, I don't know why the hell. Give me one sec. Hold on, chat. Let me. Okay, perfect. So let me, boom. Okay, so here's a tweet that comes from a guy named Amir King. He's been kind of giving updates on this situation. I think him and Chud are friends. But here's what he said, and this was a couple of hours ago. Quote, Chud update. Here are some fun facts that you'll see developing. The entire exchange was live streamed on Pump Fun. That's the streaming service I was telling you guys about before. The stream shut down at the first gunshot due to an automated AI response system. The stream is being subpoenaed. The facts according to over 100 witnesses watching the live stream. Chud told the guy, quote, I hope your day gets better, God bless, end quote. Then it goes, Chud had already walked away, was about 70 to 100 yards away. The man went out of his way to run up on Chud while his back was turned. He confronted Chud. He punched Chud in the face. Chud didn't instigate anything. Some of you are about to look absolutely stupid. Now, let's assume, let's take his bias here, because obviously he's his friend. But let's assume that this fact pattern is correct, and this is what actually went down. What are your thoughts on this?
Well, I mean, that looks a lot better than some of the alternative fact patterns for sure. So let me give people the framework that I apply when I break down any use of force case or any case I'm working on. And I get paid a lot of money to do this. And you'll be surprised to know, maybe, that there's only 5 things you need for self-defense. It's very simple. It's like a child's jigsaw puzzle with 5 giant pieces. You know, it's not, the law's not complicated. And those 5 pieces are innocence, imminence, proportionality, avoidance, and reasonableness. That means innocence, you can't have been the initial aggressor or the person who provoked the fight. If you do that, you lose innocence, you lose self-defense. And by the way, all these elements are required. If any one of them is missing, you don't have self-defense. Whatever you did, it was not lawful self-defense. So another way to think of these is each of these elements I'm talking about is a target of attack for the prosecutor. So a prosecutor who knows what he's doing, he gets that investigative report from the detectives and he's thinking to himself, all right, I have to be able to disprove one of these beyond a reasonable doubt, and then I win. And the reason he wins is, if you think about it, when you claim self-defense, like Chud the Builder is going to be claiming, you're not saying it wasn't me. You're not saying I have an alibi. I wasn't there. You're saying the opposite of that. You're saying it was me. I shot that guy, but I did it in self-defense. Well, the prosecutor knows if he can defeat one of those required 5 elements and self-defense goes away, the only thing that's left of I shot that guy, but it was self-defense is I shot that guy. It's just a confession. So the prosecutor's looking at these 5 elements to see which one looks vulnerable to being disproven beyond a reasonable doubt. If you were the initial aggressor or the provoker, you lose innocence, you lose self-defense. Prosecutor knows that. The next is imminence. You have to be defending yourself against a threat that's either actually occurring in the moment or immediately about to occur. The fist is pulled back, the guy's reaching for a weapon. It can't be something that happened in the past. It can't be something that might happen in the future. Proportionality, and this could be a problem for Chud, is you can only use deadly defensive force if you're facing a deadly force threat. If you're only facing a non-deadly force threat, you can't use a gun to defend yourself against a non-deadly force threat. And usually a punch is going to be considered a non-deadly force threat. So that could be an issue here. Avoidance is the 4th element. That has to do with whether or not you have a legal duty to retreat before you can defend yourself. Tennessee, like most states, is a stand your ground state. So in otherwise lawful self-defense, you don't have a legal duty to retreat. But what if the self-defense is not otherwise lawful? What if it has some other defect? Then you, even in Tennessee, which was one of the first stand your ground states, you can reacquire a legal duty to retreat. And then finally, reasonableness. And this is a broad target of attack because it just asks generally, would a reasonable and prudent person do what you did? And let's face it, anyone who's a social media provocateur is doing a lot of stuff that's kind of outside the Overton window and does not look reasonable to a normie jury. I mean, just imagine a typical juror in this, little town in Tennessee.
Yep.
Most white people have been socially conditioned their whole lives to viscerally recoil if they were to see a white guy call a black guy the N-word to his face.
Yep.
Right?
Yep.
They don't consider that normal. They don't consider that reasonable. So that could be an issue. Now, of course, we don't know that happened here, but so what the prosecutor's looking for is, well, if Chud provoked this fight, again, we don't know if that happened, but if it provoked the fight, that complicates Chud's claim of self-defense. That's a target for attack. If Chud went to the gun when a gun deadly defensive force was disproportionate, that's the element of proportionality, vulnerable to attack. And if Chud engaged in behavior that the prosecutor believes a typical juror in his district would find unreasonable, that's a target for attack for the prosecutor. So it depends on how the facts work out. If Chud provoked the confrontation, if Chud went to the gun when he shouldn't have, if Chud acted unreasonably, well, there's only 5 elements of self-defense, and now 3 of them are viable attacks for the prosecutor. Of course, if Chud didn't do any of that, if the facts we just heard recounted by Amiri were, he was basically innocuous, minding his own business, got attacked from behind, didn't provoke anybody, had reason to believe he was being threatened with a deadly force attack, which doesn't require death, but either death or serious bodily injury. And he had reason to believe this, that it wasn't speculative, it wasn't bare fear. Well, then he's got a very solid claim of self-defense, but we can't really know until we see evidence. We see a better video, we hear, another question is Chud going to testify? I mean, the best source for a lot of this evidence would be Chud's testimony on the witness stand, which he's allowed to do. But the moment he takes the witness stand, he's like any other witness. his character and his credibility are subject to cross-examination. And I guarantee you the prosecutor is going to bring up every clip from social media that he can where Chud is saying the N-word to black people to their face. And this is not a majority black community where this happened. Montgomery County, there's a Montgomery County in Alabama that's 80% black, but that's not this place. Montgomery County in Tennessee is about 70% white, about 20% black. But that means on a jury of 12, statistically, a couple of those jurors are going to be black people.
Yeah.
And how are they going to receive those videos? And you might say, well, it shouldn't matter, but it does matter. I mean, we're all human. We're all fallen human beings. And the criminal justice system is not some algorithm. It's not some AI system. It's just human beings making human judgment calls. And how is Chud going to take the witness stand and have all those videos? Imagine there's a jury panel with 2 black jurors on it, and they're going to see video after video after video of Chud calling black people the N-word, asking them if they're going to chimp out, if they're going to do the ooga booga. I mean, that may be funny on social media, but it's going to be a lot less funny. You know, there's a clip that went out of his arraignment this morning in court. And it's funny because Chud is there. He's white. His defense lawyer is there. He's white. The prosecutor is there. He's white. The judge is there. He's white. The bailiff is there. The bailiff was one of the biggest black guys you've ever seen. And that bailiff is just giving Chud the eye. Like you would not believe. He knows who this guy is, and he's just eyeballing him. What do you think that
this guy? If you can see on my screen?
On the Discord screen. Not seeing. I can't see it on your screen.
Oh, you can't see our Discord screen? If you open up our Discord screen, you can see what I have shared.
Okay, let me make it bigger, you mean?
Yeah, if you look at our Discord screen, yeah, you'll see I have it here.
Oh, that's the guy. That's the guy. I don't see
it
on the Discord screen, but I have YouTube open. That's the guy.
Yeah.
So imagine that guy's on the jury.
Yeah.
So there are fact scenarios in which this can and should work out well for Chud. He's a viable claim of self-defense if he was being innocuous, non-provocative. There are scenarios in which, if he, we don't know if he called this guy, Joshua Fox is the guy who attacked him. By the way, there's nothing Chud said or could say that would justify Joshua Fox punching him. No one is saying Joshua Fox was justified. But that's a completely different legal analysis question than Chud. In fact, unless Joshua Fox was unjustified, Chud has no hope. So we're all presuming the punch was unlawful. No question about that. It's not a question of Joshua Fox that black people are entitled to punch you because you say the N-word. That's not the case. I'm certainly not arguing that. It's quite possible for both these guys to be criminally liable and be convicted and go to prison. They can both be wrong. But the question for Chud is, if you provoke the confrontation under Tennessee law, you lose self-defense. It says so right in the statute.
So, I can pull up the statute here as well. Do you remember the number by chance or no?
39-11-611.
Okay.
It's because I'm a pro.
39, what is it called? 39-611?
39-11-611.
Tennessee Code self-defense. Bam. Here we go. I got it up on screen. I'm on Justia, U.S. law. And then do you want me to, is there any part of this that you want me to read it specifically or?
Well, the relevant part for provocation is paragraph E.
Okay. Right here. Okay. The threat or use of force against another is not justified.
Is not justified.
Is not.
So the important thing here is they just went through, it's paragraph E, right? So the prior paragraphs, they went through all the things you have to do to qualify for self-defense. And that's all that innocence, imminence, proportion, that's all those elements. And then you get to paragraph E, and basically what it's saying is, even if you did everything else right, even if you would otherwise qualify for lawful self-defense, you don't qualify for lawful self-defense if you provoke the confrontation. And you can go ahead and read it.
Okay, so it goes here. The threat or use of force against another is not justified if the person, one, if the person using force consented to the exact force used or attempted by the other individual. Two.
Yeah, that part doesn't matter. Go to paragraph 2 there.
Okay, 2. So this one will apply for us. If the person using force provoked the other individual's use or attempted use of unlawful force, unless A, the person using force abandons the encounter or clearly communicates to the other the intent to do so, and B, the other person nevertheless continues or attempts to use unlawful force against the person, or 3, the to resist a halt at a roadblock, arrest, search, or stop. And
I'll forget that part.
Yeah,
that involves
not,
a police stop. Yeah. So what's happening there is the statute is saying if you provoke the confrontation, you lose self-defense. Now, you can regain self-defense even if you're provoked it by withdrawing from the fight. And in good faith, you're actually trying to end the fight and communicating your withdrawal to the other party. And what's happening there, what they're doing is they're rewarding you. They're saying, listen, even if you provoke the fight, we'll allow you to regain self-defense if you de-escalate the fight. If you try to end the fight you provoked, we'll give you a prize. The prize is you get self-defense back. But you have to do that. You have to do the de-escalation. Now, in Tennessee, normally, you have no legal duty to retreat from a fight before you can defend yourself, unless you provoked the fight. If you provoke the fight, now you've lost self-defense unless you do what? Withdraw from the fight, communicate your withdrawal to the other party. Now you've reacquired a legal duty to retreat. So one possibility here is that even if Chud did provoke it, did call this guy the N-word, got a punch for it, well, if after that Chud withdrew from the fight, and I've heard claims that he was walking away from the confrontation.
That's what they're saying here.
Yeah. So that's a possibility that Chud could have to argue. He doesn't have to argue that unless there's a credible argument by the state that he provoked the fight in the first place. But if there is that argument, and where might that evidence come from? The evidence might come from this dirtbag, Joshua Fox. I mean, this wife beater, this arsonist. He might just tell the cops, yeah, that guy called me the N-word. What's it to him to say that, right? No one controls whether it's true or not. It could be a complete lie. But if he says it, it's evidence that the prosecutor can use.
I can quickly read this right here. So it says the man Chud the Builder shot yesterday has been identified as Joshua Fox, who was charged with aggravated domestic assault after allegedly threatening his wife with a screwdriver and trying to burn the house down in 2024. On April 18, 2024, in Clarksville, Tennessee, officers responded to a domestic incident at a Tower Drive apartment. Joshua Fox told officers his wife would not let him leave. His wife told officers Joshua was upset over vehicle issues preventing him from leaving. She claimed Joshua had an aerosol can and a lighter and attempted to burn the house down when she tried to take the can away. They both fell to the ground. She said Joshua then grabbed the screwdriver and held it to her side, causing her to back away. And then it says here, officers located the aerosol can and screwdriver described. They deemed Joshua the primary aggressor and arrested him for aggravated domestic assault. And then you can see here, the video that did circulate, which, me and you watched it beforehand. This doesn't really help at all for us.
It doesn't show you anything.
It doesn't show anything. So let me ask you this, Andrew. So,
by the way, can you imagine being low IQ and hyper violent enough that you're claiming you tried to set arson to a building because your ex-wife wouldn't let you leave?
Ridiculous.
I mean, wait, she's not letting me leave? I guess I'll just burn the building down around us. That makes a lot of sense.
Yeah, everyone's going down if I can't leave. So you mentioned earlier, Andrew, that proportionality, one of the 5 elements of self-defense is proportionality.
Right.
Now, when I normally look at difference to every every state is different with their self-defense laws, etc. But it's, and then imminency is another thing as well, right? Wouldn't you be able to argue that getting punched in the face, though it might not necessarily be, lethal force at face value, it can incapacitate you to a degree where they can continue to assault you and it can get deadly very quickly. And in that, you're defending yourself from getting knocked out or, getting some serious bodily injury. Because I've heard, either serious bodily harm or imminent or death. And serious bodily harm, I think me and you have actually, I learned this from you, if I'm not mistaken. Serious bodily harm can be anything from like maybe a fracture on a bone. It doesn't have to necessarily be deadly. So could a punch in the face suffice for that?
It could, right? We've all seen news reports and videos of people knocked out by one punch and they're knocked unconscious. They fall, they hit their head, they die. Here's the problem. Again, the legal system is run by human beings, right? Judges see lots of fistfights come through their courts, and they almost never see anyone die from it. It does happen, but it's very rare. Statistically, it's about 2% of cases. And judges know that if they say, all right, I'm going to treat every punch as if it were a deadly force attack that you can respond to with a gun, they're turning every fistfight into a gunfight. And they don't want to do that. because they know the majority of fistfights don't end that way, don't end with deadly force. So we can say to ourselves, well, listen, if you're the 2%, your risk of death from that punch is 100%, right? I mean, you just got killed by that punch. And by the way, if you get killed by the punch, then the state will call it deadly force. They'll call the punch deadly force. That doesn't help you in self-defense, of course. Yeah. But the problem is the law, if it's an, how can I put it, a non-aggravated punch, if it's a typical fist fight between two guys of similar strength, size, and fighting ability, invariably, the courts are going to treat that punch, that fist fight, as non-deadly force. You're not privileged to respond to it with a gun. Now, are there fists you can respond to with a gun? Yes. If the fist is of a nature that it's likely to cause death or serious bodily injury, if a young Mike Tyson is throwing the punch, that's different. If the person throwing the punch is much larger or stronger or has an exceptional fighting ability the defender doesn't have, that could be a punch that's reasonably seen as more likely to cause death or serious bodily injury. If there's multiple attackers, well, then it's all their punches, right? It's a multiplying effect. That could be it. If it's a sustained beating like George Zimmerman suffered at the hands of Trayvon Martin, that's not a traditional fist fight. And by the way, this happens a lot in the Black community. I mean, white fist fights and black fist fights are not the same. Yeah. You don't generally see a white guy knock down his opponent and then start stomping him on the head. But we all see those videos on social media in the Black community. But the point is, before you can go to the gun, you have to have a reasonable belief that you're about to face a deadly force threat. Can a fist meet that standard? It can, but typically you need some kind of aggravating factor that's more than just the fist. Size, strength, fighting ability, disparity of numbers, sustained beating. That first thrown punch is generally not going to be enough.
Fair enough. So, and
now here, there was a first thrown punch, and then the two guys go to the ground. I can tell that from the video, but I can't tell who's doing what. If Joshua Fox has mounted Chud and is beating his head into the sidewalk like Trayvon Martin was doing to George Zimmerman, yeah, that looks like a deadly force attack to me. But I just can't tell from the video if that's what's happening.
Yeah, and I like that you made that distinction. Like, a punch in and of itself is not enough. You need other factors in. So, you know, right. I'll give a scenario and then we can kind of go through.
Or like if it's a large man and a small woman, right? Yeah. I mean, anytime a man's attacking a woman, generally it's kind of baked into the cake. You have the size, strength, and fighting ability disparity there.
So in other words, a woman, like in the same scenario as Chud, is going to be able to go up the escalation ladder way faster, justified, than someone like Chud the Builder, because obviously he's an able-bodied man, bigger, etc. So, you know,
assuming he's able-bodied, I don't know if he is. I'm assuming it. But say, for example, the victim of the punch is someone who's on prescribed blood thinners, right? Yep. Well, if you're on blood thinners and you take a punch to the head, it'll kill you. I mean, you'll get a brain bleed and you'll die. So if you're, I don't know, a 70-year-old retiree on blood thinners and somebody comes up to punch you in the head and you shoot that guy, you have a credible argument that, listen, that punch, maybe not to a healthy person, but that punch to me, that was a deadly force attack. And therefore I responded with deadly force. But again, there's an aggravating factor there, the exceptional vulnerability to injury.
Yeah, and I think this is very important that people understand this, that, like, you know, the punch in of itself is not enough. However, you know, if you add in other factors, you can quickly, you know, justify, depending on if you got a good lawyer, there's certain circumstances. So let's go through with, let's assume this fact pattern is correct.
People have to understand what you're doing is you're telling stories in court, right? You're telling stories to the jury. The prosecutor is telling the jury a story of guilt, and your defense attorney needs to be telling the jury a story of innocence.
Yep.
And it's all, you know, I mean, humans, as all of human civilization, the best way we learn, the most compelling information we get is in the form of stories. It's one of the reasons your defense attorney is so important, why you need a good one.
Yeah. So let's go with this fact pattern here, and then we can explore other ones. So this is what 100 witnesses are saying that watched the stream live. Chud told the guy, I hope your day gets better, God bless. And I'm assuming this, and then Chud had already walked away. So we could argue that this is a disengagement and opens up, even if he walked up and said, you know, F you guys, drops the N-bomb, etc., there's an altercation, and then he says, well, I hope your day gets better, God bless, and he walks away. You can argue that that's a disengagement. Then he walks away, says about 70 to 100 yards away. The man went out of his way to run up to Chud, so he closed the distance. While his back was turned, He confronts
I would
Chud.
argue that's a new fight.
That's a new. I would. Yeah.
So once you withdraw from the, you do that withdrawal and communication.
You get a
even
refresh.
if you provoked the first fight in the first place. Once you've effectively ended that first fight by withdrawal and communication. Now, assuming this is true, right?
Yeah.
If Joshua Fox then runs up behind him and attacks him, that's a brand new fight that has nothing to do with what happened before.
Yeah, and I think it's important people understand that even if you provoke the fight, if you de-escalate and disengage, and then they come back and attack you after the fact, you basically get a second shot at the apple, a second bite at the apple.
That's right.
Because you disengaged, and then you walked away, and then the person comes in, and again, I'd love to correct me if I'm wrong, Andrew, you're the expert here. From what I've always looked at it, like the person that closes the distance typically is the aggressor in most situations, and then that gives you a better position to argue self-defense because you're not they close the distance on you. Now you can argue, well, I don't want to. I'm going to stand my ground and defend myself because this guy came up to me. So even if he did go in and be like, "F you, N bombs, blah blah blah," all this other stuff. Him disengaging, saying, "I hope your day gets better, God bless." You can reasonably believe, look, this is him walking. This is him ending the conversation, walking away. Then this guy closed the distance.
Yeah, so, I mean, on the legal merits, it's possible to imagine a scenario where the other guy closes on you and you're still the provoker, for example. Like if you're shouting the N-word at him continuously and he closes on you, you could still be made to look like the provoker. But normally, the position you want to be in as a defendant in the use of force cases, you don't want to look like you went to the fight. If the fight came to you, it looks a lot more like self-defense than if you went to the fight. I mean, one of the problems for Chud is there's a video out there. Maybe I can send you the link to it.
Yeah, please do, and I'll pull it up on screen.
Let's see. Yeah, it's this one. Is it okay if it's on X?
Yeah. I'm using X for all the stuff. Yeah, I mean, you can even share your screen if you prefer.
I'm a boomer. I don't want to screw that up. So
Okay.
I just texted you the link. And it's where he pepper sprays this guy he's having a confrontation in.
Oh, yeah, I know which one.
And the reason it's interesting is it's because he's not really always defending himself with the pepper spray. It's like,
well, let me see.
Let's see. I'll let you pull it up.
Yeah, I don't know.
The thing I want people to watch for here is you can use pepper spray in self-defense. And there are things this black guy he's in a confrontation with, there are things this black guy is doing that you could argue deserve pepper spray. But then Chud, as the black guy wanders away, Chud follows him and pepper sprays him again.
I think this is
and
the
when
clip
you're
talking
going
about,
to
right?
the fight, let's see.
Yeah, if you open up the Discord, you should be able to see my screen as well. And I have the video here too. I could play the audio for you. We can react to it.
I don't know what open up the Discord means. I can see you and I can see me in a little window, but I don't see your shared screen.
If you
I'm sure that's a me problem.
Yeah, if you open up Discord, like enlarge it.
Yeah, I got it as big. I have a giant 4,000K screen, and I've got it as big as I can make it.
Oh, so you have one screen. You only have one screen?
No, I have three.
Oh, try to put the Discord in one screen by itself, if you can. Make it take up one full window, and then that way you'll see me, then you'll see yourself, and you'll be able to also see.
Well, I can see it on YouTube. That is the video I'm talking about.
Okay, you want me to play it, and you can hear the audio?
Yeah, go ahead and play it.
You heard me, nigga. Fuck your shit.
Yeah. So he's got this confrontation with this black guy here.
Got shit. You got lens crafters on,
he's going to bring
pussy-ass
pepper
nigger.
spray into play.
Mm-hmm.
This dude,
The
that's
guy
why you
knocks his
making
hat
money
off
and you
and
ain't.
he pepper sprays.
And he got the V-Lone on. What
Which
you wearing,
arguably
nigga?
is
Your
fine.
work shirt?
But then he follows the guy.
Yeah, because you fast forward a little bit here. So he knocks his hat off.
That's right.
Bitch. You're a bitch, bro.
Calls him bitch.
Literally, all you do is talk about your dick.
Okay, knocks the hat off, walks away.
I'm sorry. I'm a nigger. Come back over here.
Okay. Let's
Come back over here.
Let's not fight.
And I think once he
Touch me.
when someone's hands go to your face, that's about as aggressive as you can be without having a weapon in your hand. So I think knocking the hat off, that deserves pepper spray.
Yeah.
But then he doesn't let the guy, he follows the guy down.
When he walked away,
So
yeah.
he can keep filming for clicks. And that doesn't look like self-defense anymore.
Yeah.
Again. Touch me again.
I don't want to get pepper
So he says, touch me again.
sprayed. I really
And the guy says, I don't want to get pepper sprayed.
don't.
Go pick up my hat, nigger. You heard me, nigga.
So he grabs the hat, or he went for the spray, and then Chud sprays him.
I would say that's legitimate to pepper spray him too. He's the guy's trying to disarm him, would be my argument, right?
Yeah.
Is trying to take away his defensive weapon. But after he sprays him there, again, he follows the guy. He doesn't let the guy just walk away because he wants to keep filming, I guess.
Yeah. So he sprays him. Guy walks away.
I thought. Thank you.
Hey, don't hit me with that shit.
I ain't gonna pray you. That motherfucker wants to put his hands on me again.
Okay. Yeah. So, here, and then let me go back. So, okay. So with this fact pattern here, assuming this is all correct, would you say that he has a strong self-defense case with this fact pattern, assuming it's true? Which
Well, for some of it, yes, but not for other parts of it.
Yeah. Let me read through it one more time because I know you can't see the screen. Chud told the guy, I hope your day gets better. God bless. Chud had already walked away. Was about 70, 100 yards away.
Oh, this fact pattern. I'm sorry. I thought you were talking about the pepper spray.
No, not the pepper spray one. Not the pepper spray one.
Wait.
This one.
No, this fact pattern looks good. It looks good for self-defense. The trouble is, here's the thing.
Yeah.
Every time I consult on a case, I'm talking to a client, and the client tells me what happened, and it sounds great. Yeah. And then I look at the surveillance video or I look at the body, and they left out all the shit that makes them look bad, right? So all of this could be literally true, but if they're leaving out all the bad stuff, it's not the totality of the circumstances. So it's a way of lying by omission, right? You leave out all the bad stuff, and the good stuff sounds great.
Yeah. So assuming this fact pattern, because when I saw this fact pattern, I said, well, if this is actually true, I think he has a pretty good case here. Now so we talked about individualism when it comes to you being attacked and how that plays a role, right? We gave the blood thinner example earlier. With someone like Chud, right? Would he be able to argue, look, I get death threats every day. People dox my address. People say that they want to kill me, etc. We also know, I think it came out that this guy had made threats to, attack Chud. Now, obviously, me and you had a discussion about that he'd have to know that beforehand. But would the fact that the guy is basically hated by everyone, I mean, here's a tweet I have here that I showed you earlier from a rapper with 2.5 million followers saying, we're quick to take our own brothers out, but this white racist dude I keep seeing still walking around unscathed. Tell Buddy to come to Memphis. I'll figure out a way to make it justified and put Buddy ass in the dirt on my baby. Would the virality of his antics and enormous amount of death threats and messages he gets, hell, even having famous individuals with large followings, call for his death on the internet, would all of this play a role in him being able to escalate the use of force ladder quicker than a normal situation?
Yeah, so it can. So the more specific the threat, the more relevant it is to his claiming a reasonable perception of the need to go to the gun. So, for example, I don't know what Chud knew, but let's imagine that Chud knew that this particular guy, Joshua Fox, had threatened him with death. Next time I see you, I'm going to kill you. And Chud knows this guy made that threat, and then he sees the guy on the street. Well, that all goes to Chud's state of mind. That's part of his reasonable evaluation of the intensity of the threat and whether or not he should go to the gun. But the more general the threat becomes, the more diffuse the reasoning becomes. So if it's, hey, this rapper said one of my black fans should kill this guy, you can't just go shoot every black person you see because you might be a fan of that rapper who's trying to kill you. It becomes a much more diffuse argument. Is it still relevant? It could be. I mean, you can make that argument. You could say, listen, I know there's a lot of black people who are looking to kill me because of my antics, and then I was attacked by a black person. That's different than if I was attacked by a white person. It's a different dynamic. And then you have to try to convince those two black people on the jury of that argument.
Yeah. So, because, the thing when I look at this, I'm like, look, his antics might be inflammatory. Obviously you can make the argument he's provoking, doing X, Y, Z. But that doesn't necessarily mean he doesn't have a right to defend himself, even especially like we talked about before, provocation, assuming he disengages, etc. What about? Yeah,
just to be clear, whatever his antics are, he has the same right of self-defense as I have, as Myron has, as anybody has. It's not. I remember famously in the Rittenhouse trial, one of the prosecutors in closing arguments argued to the jury that Kyle Rittenhouse should have just taken the beating. Sometimes you just have to take a beating. No, that's not true. That's not the law. You have a right to defend yourself. But if he provoked a confrontation, just as if I provoked a confrontation or Myron did, you risk losing self-defense. It's the same for all of us.
Yeah. So we have the circumstances with obviously the fame, people marking him for death, etc. So he's going to be on a heightened alert, which all goes to his benefit. Now, from what I also understood, and you can go ahead and give other fact patterns, I've also heard that they went to the ground. Once you go to the ground, and because apparently that's when the shots were fired, when they were on the ground. Now, obviously, this goes from a punch, and you can make the argument potentially that going to the ground is an aggravating factor, where and it's so crazy how self-defense, for those that are listening, guys, self-defense changes millisecond by millisecond in the interaction.
It's
based
very
on what's
dynamic.
happening. It's extremely dynamic, guys. Like, we're trying to kind of give you guys different scenarios where it could be justified or not justified. But, like, you know, I love the fact that, like, Andrew made the distinction. Look, if you just get punched in the face by itself, that's not going to justify use of force. However, you're Chud the Builder, you're famous, people hate you, people make death threats against you, someone punches you, then you guys go to the ground. Well, that changes things significantly from, let's say, maybe Andrew getting punched in the face by somebody random versus him getting punched in the face and then going to the ground. So...
Hey, I get my share of death threats.
I'm sure, yeah. I'm sure. Me too, actually. Me too. So would it
But like if they're on the ground, right?
Yeah.
If you're on your back on the ground and you're mounted by a dude, he can punch you with abandon and you can't really throw a punch back because you can't, you know, your elbow hits the ground. You can't throw a full force punch. Plus, every time you get hit in the head, not only does the fist hit you in the front of the head, but the ground hits you in the back of the head. So it's like getting punched twice every time you're struck. It's a very vulnerable position unless you're trained in defending yourself from that position. I mean, if you know BJJ, there's things you can do, but a normal person, they are in an extremely vulnerable position. That's why George Zimmerman was justified in shooting Trayvon Martin. Even though Trayvon Martin, they say he was unarmed. What they mean is Trayvon Martin didn't have a weapon, a synthetic weapon like a gun or a knife. But of course he was armed. Trayvon Martin was armed with his fists.
Yeah.
And he was armed on top of George Zimmerman. And he was armed with the gravity of Earth that let him pin Zimmerman to the ground where he could continue beating him. So once you're on the ground, it all changes. Yes, if Chud can articulate that same kind of dynamic. Listen, I wouldn't have shot the guy, except I was getting my head beat into the sidewalk. And every time that happens, you know, you could lose consciousness in an instant. You're suffering brain injury every time it happens. Then it's a much more robust argument. Again, he still has to deal maybe with the provocation issue, right? If it happened, he still has to deal with that. But if there was no provocation, then we're right to proportionality. Then we're on how do the dynamics of the fight change if you're pinned to the ground. Now, I'm not sure. I don't know for sure if the shot was fired on the ground. What I see in that little video clip we have from the women in the office building is it seems to me like that's when they go to the ground. But I think the shot was fired prior. I think the women started filming because they heard a gunshot and went to their window and saw the fight. Because I don't hear a gunshot in that video.
Oh my God.
I hear the women's voices.
yeah, so you can see,
Holy shit.
They're out here.
and we don't know
Somebody
when
got shot.
the shots were fired.
Yeah.
Or we also don't know if they went to the ground first, shots were fired, then they got back. Who knows if this was the second time they went down to the ground or whatever. That's why the footage is going to be so important.
Or for example, Chud might be able to explain, listen, I carry a gun, and this guy saw my gun. So the moment he approached me, he went for my gun. Well, that's a gunfight. Then it's two guys fighting over a gun.
And you can also...
By the way, I am curious about one thing. I don't know if anybody knows the answer to this.
Yeah.
Maybe somebody in the chat does. But my understanding is Chud had just come out, you know, a few days prior, he'd been thrown out of a very good steakhouse in Nashville. If you've never been there, I recommend it. The Bob's in the Omni Hotel in Nashville. It's excellent. But apparently he was there having a steak and ran up a bill. And I think he was filming himself and the staff didn't like it. So they asked him to leave. Anyway, he wouldn't leave. He ended up getting arrested over that. That's why he was at the courthouse.
He left, but what happened was he left, but he said, I'm not gonna pay for the bill because you guys are kicking me out. Like, you know.
All right. So they got him for, I guess, theft of under $1,000 and disorderly conduct. That's why he was at the courthouse.
Yep.
Well, if you're in the courthouse because you have to answer a charge, how's he have a gun when he comes out of the courthouse? Every courthouse I've ever been in, there's security.
Yeah.
You can't bring a gun in there.
Yeah.
So when he had just come out of the courthouse. Where the hell did the gun come from?
Yeah, I don't know. Yeah, I don't know if he was there for court or what happened, or he was just in the area. Yeah, but I do know. Yes, a couple of days prior, he had been arrested for theft of service. But the other thing I was going to say too. So, okay, we have we talked about proportionality. We talked about going to the ground. We talked about what about if here's something else that came up that I also heard. Apparently, when they were fighting, the guy said, "I'm going to kill you" multiple times to Chud. Would that be considered an aggravating factor as well?
Yeah, because it's not just a fist fight. I mean, most of us men have been in fist fights.
Yeah.
We probably didn't tell the other guy, "I'm going to kill you." It was just a fist fight. But if you convince the other guy you're going to kill him, now it's a deadly force fight. There's no reason for him not to go to a gun, not to go to a knife to defend himself.
Yeah. And guys, if you guys got questions on self-defense specifically, make sure to get them in. Jock, I saw your question. I'll answer the finance stuff after we finish up with Andrew. I want to keep it the focus on the self-defense stuff for now, guys. Then once he goes, then I can cover the other stuff. So, okay. So, have you heard any other fact patterns besides the one I gave you where allegedly he was walking away 70 to 100 yards away? This guy closed the distance on him, attacked him. Are there any other fact patterns you heard?
I mean, I'm seeing a bunch of different stuff, but I don't give it any weight because it's normally anonymous accounts on X with 44 followers, and there's no way to confirm if they're just making stuff up or not.
So I have this video here. We could react to it real quick. This is I know you might not be able to see it, but you can hear the audio from this guy, the person that got into a fight with him. I'll play it real quick and see what your thoughts are.
Yes, this is my favorite filter. No, I don't like cats. I just think the filter is dope. Anyway, for those who don't know what I'm talking about, a plumber came to my apartment today, banging on the door like he was police. I got PTSD. I've been arrested at this residence too many times. So I just hurry up and open up the door because they ain't finna kick down my shit like they did last time. Anyway.
Yeah, I don't know what this music is. I've noticed past couple months he's been messing around with people with his live streams. Oh, is this him, what he said? Okay, the district attorney generally identified one of the men as 28-year-old Dalton Eatherly, a controversial online streamer. Witness Grace Roberts told WSMV she recognized Eatherly right away when she saw him being wheeled away on a stretcher. It's actually not surprising, Roberts said. It feels like it was one of those things that was bound to happen. Eatherly is known for online for approaching people in public while live streaming using racial slurs, claiming to be fighting for freedom of speech. I've noticed for the past couple of months he's been messing around with people with his live streams. Roberts said he just knows how to really get under people's skin, and it doesn't help when you're on camera in front of God knows how many people. Okay, let's see. Fast forward here. It's not clear if Eatherly was streaming at the time of the altercation outside the course, but he was arrested last weekend after allegedly refusing to pay for an almost $400 worth of food he ordered while live streaming at a downtown Nashville restaurant. Metro Nashville police say that when the restaurant asked him to stop streaming, he started making racial statements, yelling and screaming. Really took the time out of your day to come out at your home, get dressed up, and find people to mess with, Roberts said, and is very specific here, specifically attacking black people. Let me see here. Is there anything else from this? Okay, there's nothing else with this guy. But that's him. And then this is a clip of them fighting. This is him getting wheeled on a stretcher. I think he got grazed or hit. And then, do you want me to play the audio when he talks to the cops? It'd be good to get your reaction to that.
I don't think I can hear it.
Oh, you can't hear it?
I can't hear it. No, because it's delayed on YouTube, and so I hear your voice, introducing it before I hear the actual video. I can't figure out how to do the screen on screen in Discord.
What I could do is, you know what I'll do? I'll just play it in full, and then you'll hear it, and then you can kind of give us your thoughts. Does that work?
Yeah.
Okay.
On the corner.
I'll just play it in full without any interruptions, and then you can.
Walked past him. He was sitting on the corner. I walked up to him because they were pointing at me. They were laughing. They were pointing at me, and I said, "What's up, guys? How y'all doing?" I said, "Y'all like the new suit?" He said, "Walk away from me." I walked away from him. He came back up to me. He literally said, "I have PTSD. I feel like I'm in." He said, "You start saying all that chimp out shit to me, I'm gonna hit you." He hit me, started wailing on me, even after I had to defend myself by shooting him. He was still wailing on me.
Where's your weapon at?
They have
The trouble is, it's like the Amiri King fact pattern. It's like what's being left out, right? Of course, the way he's telling it, it sounds great. But I can't help but wonder, what would be inserted if you actually had a transcript of the encounter?
Yeah.
That would make all the difference.
I keep playing it.
And again, tiny changes in facts lead to huge changes in legal outcome in use of force cases.
Absolutely. Here, I'll keep playing it. It's almost done. It's like 10 more seconds.
Is that yours?
Yeah.
Yeah. Oh, no, you guys are going to do your thing. Okay. He has a graze. I call it a graze to the left arm. He has slight abrasion right here on his head, maybe some scrapes, slight lightheadedness.
Okay. So what are your thoughts on that? I mean, I think he talked way too much to the cops. What are your general thoughts on that?
Okay, so I mean, if I shot someone in self-defense, would there be a very limited number of things I might say to the police? Yeah, there might be. I might want to make sure that exculpatory witnesses are identified, exculpatory evidence, the bad guy's knife is secured into evidence. I might want to say I acted in self-defense just to get that in the record as quickly as possible. But at that point, even me, arguably, the nation's leading expert on use of force law, I'm shutting my mouth.
Yeah.
Until my lawyer shows up. And I may not even talk, by the way. A lot of times people say, you should tell the cops, you're not going to say anything until your lawyer shows up. I got to be honest. You shouldn't say anything when your lawyer shows up. You should never be saying anything. Your lawyer should be doing your talking for you. Even if your lawyer is sitting next to you, every word you say can be used against you in court. The better model is you whisper to your, they ask you a question. So what happened? Whisper in your lawyer's ear. He gets to recount what you said. That can't be used against you in court. Those are his words. But you're still getting your message of what happened out to the investigators. Generally speaking, for most people, if they're not sophisticated about this kind of stuff, especially if deadly force was involved, you're going to get arrested anyway. Just comply with the arrest, get cuffed up, get a lawyer, and let your lawyer do your talking for you. The prospects of you talking yourself out of arrest are zero. Once, especially if deadly force was involved, you're just going to get arrested. And anything you might say to try to make your situation better is almost certainly going to make your situation actually worse.
Now, I have a theory on this, and we can kind of put our thinking caps on. I agree with you that he was more than likely going to get arrested no matter what. And I think based on, the fame, how viral he is, what he's doing, I looked at it like, you know what, dude? Anytime you have, a racially sensitive case like this, between a white person, a black person, there's some kind of use of force. What I've realized is, especially after the whole George Floyd saga, most district attorney's offices and law enforcement agencies are just going to arrest and kind of let the grand jury decide if they want to pass a true bill of indictment later on. But they'll make a probable cause arrest.
He shot a guy in a public street, however meritorious. It could be completely lawful self-defense. He shot a guy on a public street outside a courthouse. You're getting arrested. There is no world in which you're not getting arrested. Because who's dealing with you? The responding sheriff's deputies or marshals or local cops? What ends up happening with you is above their pay grade. That's not their problem.
Yeah.
What they have to deal with now is you've got a gun and you just shot a guy. They're just going to arrest you. That's just what they're going to do. And then you become someone else's problem.
Yeah, because and that's kind of what I was going to say here. Like, they don't have and I like that you mentioned the whole pay grade thing. Yeah, that's going to be a prosecutor decision in higher levels of the law enforcement agency.
Yep.
Like, the guy that's there wants to cover his own ass, right? So he'll probably make the probable cause arrest, bring you in, and let it get settled. And I've noticed with like these racially sensitive cases, it's almost like the law enforcement agency, the state attorney's office, nobody really wants the culpability of dismissing the case. So they'll prosecute it no matter how meritless it seems, just so that they can say, look, well, we pushed it to grand jury and the grand jury didn't indict. That's your own peers. Don't be mad at us. And I've kind of noticed this uptick you're lucky if you get that outcome. Yeah, it's so like you remember the Michael Brown case, the hands up, don't shoot nonsense case, right? That this huge black guy attacked this relatively small white officer. The officer shot him and killed him. That prosecutor, this is it was in St. Louis, Missouri, I believe. That prosecutor had been the prosecutor there for like 30 plus years. He'd been the prosecutor forever. And he decided, prosecutors don't have to present the grand jury with both sides of the case. They only have to present their side of the case and get an indictment. And of course, that's why it's easy for prosecutors to get an indictment. Anytime you only hear one side of the argument, it sounds good, right? But in that case, the prosecutor went to the grand jury and did something very unusual. He presented them with both sides of the case. And the grand jury said, well, we're not going to indict this officer in the Michael Brown shooting. And that was it. That was the end of any prosecution of that officer. That prosecutor who made that decision to tell the grand jury both sides of the story, after being a prosecutor there for more than 30 years, the next election, a young black lawyer ran against him and beat him. He lost his career over that decision. And every prosecutor in the country knows the story I just shared with you. Wow. So every prosecutor knows if there's a white-black shooting, and I decide not to go hyper-aggressive after the white guy, I could lose my whole career over that decision. I'm not going to do that.
Why would I sacrifice my career for this white guy? I don't even know if what he did was lawful. I don't know.
Yeah.
Maybe he is just a murderer, right? He should sit in the hot seat and suffer for that decision to fire that shot, not me.
Yeah, and I've noticed that with these cases, like it's almost like they arrest now and ask questions later and let it and just pass the buck to the grand jury and to a jury trial if it comes to that point.
And ultimately to the jurors.
Yeah.
Right?
If it gets there. So
because you have to keep in mind, especially for racially energized cases, for the prosecutor, it's a win-win decision to take you to trial, right? Because either they get a conviction, and by the way, they can get a conviction even if you're innocent. There's at least a 20% chance that you get convicted, even if you did everything right in self-defense. Innocent people get convicted all the time. So they could get a conviction, and then they get to say to the media, look, I was right the whole time, right? The jury found him guilty. But even if they don't get a conviction, like Zimmerman wasn't convicted, Rittenhouse wasn't convicted, but those prosecutors get to go back to their tribe, normally it's a left-wing tribe, and say, listen, I did everything I could.
Yep.
I fought the good fight for all of you. Vote for me for re-election.
yeah.
So they win there. They win the political capital game, even if they don't win the conviction.
Yeah, and it's like, and that's kind of the problem when you're like someone famous and there's like, and it's high profile. It's almost as if like it's a guarantee you're going to get arrested so that they can pass the buck to somebody else. And what I've noticed with state cases is like they don't have any shame for losing. Like the feds have shame for losing. Like the United States Attorney's Office prides themselves on being 95% plus for winning. Versus like, these state attorney's
98.
offices, they don't care. Yeah, 98, depending on the district, right?
Yeah.
But like at the state level, I've realized like they have no problem with doing, taking an incredibly sloppy case and doing it just on the premise of, well, we tried, we lost, it is what it is. They're totally okay with taking L's.
It's even worse than that. They'll take a terribly sloppy case, a case that really doesn't have a prospect of winning, except, the dice get thrown and you get the 20% bad luck. They'll take a case like that. It could be you. Right? It could be you. And your lawyer's telling them, listen, this is not a strong case for conviction. Don't take this to trial. And they'll say, yeah, but we just hired a new prosecutor and she's never done a trial case. So we're going to give her this one. Just so she can gain some experience.
Crazy.
We don't expect her to win, but she'll gain trial experience. And who knows, maybe your client will lose.
Yeah. Yeah, and litigating in a criminal case, right, is very valuable experience, guys. A lot of lawyers, people forget, a lot of lawyers don't even litigate. So litigating and criminal defense attorneys, litigate quite a bit, and that's a skill set that a lot of lawyers actually don't have. So,
90% of lawyers never litigate anything. They work for corporations or they do trusts and estates, and they're never in a courtroom.
Yeah, they don't do anything, which obviously, that increases your. I've seen it so many times where someone will become a public defendant, then a prosecutor, then go and become maybe an AUSA, and then after they do all that, they have all this litigation experience. Then they go into the private world and make a whole bunch of money because they actually understand how to argue cases in court versus like these other armchair lawyers. So, okay, Andrew, so let's go through this. Let's go into a dream world. Let's say you're his lawyer. What would you do? What would you start trying? How would you start preparing for a case like this? You have a high profile guy, racial, obviously very racially charged case, national headlines. Everyone is talking about it. You know who your guy is. How would you prepare if you were his counsel?
Well, there's nothing we can do about his baggage, right? All his social media stuff. We can't do anything about that. But what's really important here is everything in self-defense is evaluated from the state of mind, the mens rea, the mental state of the defender, what they knew at the time they fired that shot. So it's really important to pin down as early as possible. Did he know this guy? Had this guy threatened him? What's the nature of the threats he's been getting? Because to the extent you can document that was in his mind, that was in his knowledge at the time he fired the shot, that's all admissible. And you can get that in front of the jury. If you wait too long and you try to claim that, it looks like you're fabricating it after the fact.
Okay.
And you can't prove that you had it at the time of the possession. And I see this happen. There was a guy in Detroit who was sleeping 2 o'clock in the morning. Someone tries to kick in his door, he thinks. He grabs his shotgun, and this is Detroit. There's home invasions everywhere. He grabs a shotgun, goes to his front door, opens it up. A figure lunges across the doorway, not into the house, but side to side. He shoots it with the shotgun. It turns out to be a drunk black girl who was just at the wrong house. This is a white guy. And this white guy tried to introduce into evidence, hey, I live in a neighborhood with a lot of home invasions. I thought it was a home invasion. And his lawyer tried to put a big map in front of the jury showing every home, and they're everywhere. And the judge said, no, I'm not going to allow it because you can't demonstrate to me that your client knew about these home invasions at the time he fired that shotgun. The fact that these things are true is not enough. Your client needs to know it, needs to have known it at the time. So one of the things the lawyers for Chud need to be doing right now is establishing his present state of mind, what knowledge he had in his mind. They don't get to do that later. It'll be too late later. And I hope they're smart enough to do that.
How quickly, because this is obviously very important because and I love that you mentioned that because I've told my audience this a bunch of times, right? A lot of people like to armchair, quarterback it and say, well, this isn't, he's guilty because he provoked this, blah, 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 but they never actually look at all the factors. And I've always told people, like you said earlier, a small change in the fact pattern can have enormous, ramifications on the outlook of the entire case. So, ironing down the narrative early on is obviously very important to get their state of mind because that will obviously dictate if the use of force was reasonable, which is like the, ultimate situation. Was it reasonable given the facts and circumstances known to the person at the time they pulled the trigger?
Right, exactly.
So my question is, knowing that, how quickly do they need to get in front of their client to establish this fact pattern? Well, are we talking within 48 hours, 72 hours? Because obviously you need time to secure counsel. He's not on bond, so it's not like he's free.
The first time he sits down with his lawyers, if the lawyers are competent to handle this case, they should be doing this. Okay. Maybe not the first 15 minutes, but within the first hour.
Yeah, and this is why it's so important.
But the lawyers need to know they need to do this. Most lawyers don't know anything about self-defense law. They'll treat it like a car accident or DWI or where these things don't matter so much. And then later they'll learn, 3 months from now, 6 months from now, when they go to introduce this evidence in the court and the prosecutor says, no, there's no evidence he knew that at the time. And the judge says, yeah, that's right. You can't get it in. And they're like, damn it. If only we had addressed this right away, we'd be good. And the trouble is, if you take out all that personal knowledge stuff, you're literally stripping out the reason why he felt he had to go to the gun. And without that, you don't have self-defense.
How quick does that need to be established? Because obviously this is critical. Like, for example, I'll give you a perfect example.
It should have happened the day after the shooting.
Okay, so within 24, literally, as soon as counsel's retained, that first sit down. And this, again, for the guys that are watching, this is why you don't talk to the cops. Because now, any discrepancy between what he tells the lawyer versus the police is going to be exploited.
Right. So imagine he told the cops, yeah, I've never seen this guy before. Well, then all that shit goes out the window.
Yeah.
Right?
Yeah.
And I'm not saying anyone should lie. I'm not telling anyone to lie. I'm just saying you lose options when you pin yourself to positions by talking to the police.
Yeah. Yeah. No, and that's critical because from what I understand, this guy had made threats on Facebook saying, I'm going to find this guy, I'm going to hurt this guy, blah, 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 right? And we don't know if Chud knew that at the time, but obviously that makes a huge difference because if he had known that would be, like you discussed before, a potential aggravating factor to justify his use of force. But you're going to say something?
Right. So again, I'm not suggesting any lawyer should advise their client to lie, right? I'm not saying that. But a lawyer could tell his client, listen, we're only going to be able to introduce in the evidence stuff you knew at the time you fired that shot. And we did some social media research, and we came across like a bunch of death threats. Did you know that at the time? And he'll say, no, I didn't. And the lawyer go, are you sure you didn't know this at the time? And he'll go, oh, yeah, no, I definitely knew that. Right?
Yeah, I mean, look, that's how it could potentially go sometimes. I mean, but like, and this is why, I think the state of mind of the individual, and this is why having a good lawyer is so important. Because we don't know what Chud knew at the time. We don't know because apparently it was a group of them, and he was with a group of people. Even though one person came at him, we don't know if the people in the background say, yeah, get him, kill him. Like that could all
that would matter too.
That would all matter. So I agree, and I tell people this too. There's a reason why, right? When you get into a law enforcement shooting, when I was an agent back in the day, if we got in a shooting, it was common practice. You don't talk to anyone for like 48 to 72 hours. Then you sit down with internal affairs and give them the full story. You don't talk as a law enforcement officer, a sworn law enforcement officer with a gun, where you have you're carrying as a part of your job. You have the ability to utilize lethal force. If you get in a shooting, you don't even talk for 24 to 72 hours. And the reason why is because you have an event like that. It's hard to really get all the facts that led you to make that decision to use deadly force immediately. So you need to kind of get with your lawyer, figure it out. What did you feel at the time, et cetera. And then you go and you sit down with internal affairs with your lawyer. So,
and it's actually just biology. So It's not because the cops are lying, but cops tend to be involved in more gunfights than normal people, and they've just learned from experience. The way your brain captures and stores and recalls information in the normal course of events is completely different than the way your brain works when someone's trying to kill you. Your brain just doesn't work the same way. The adrenaline dump, the tunnel vision, and if you were to describe immediately after the gunfight what you think happened, because you don't actually know what happened. You don't see everything. You know, we see these body-worn camera videos, and of course we can see everything perfectly because it's a camera. But that's not the way the human eye works. The human eye looks at this thing or that thing or some other thing. It's not looking at everything with clarity at the same time. The cop's eye did not see what the body-worn camera saw. Those are two different things. But if you recount what happened in your gunfight the hour after it happened, and then you tell it again 12 hours later and 24 hours later and 48 hours later, every one of those recountings is different. Yeah. They're different because your brain chemistry is settling. And it's not that one of them is a lie or even necessarily that one of them is more accurate than the other, but they are going to be different. And so law enforcement has learned, listen, if we take 6 stories from this guy, we're going to have 6 different stories and it's going to look terrible in court. So let's let the brain chemistry settle. Let's get one story from him, and that's the official narrative of what happened. I say story, I don't mean that he's lying. The one official narrative, description of what happened.
Yeah, and this is why it's so important to not talk to the cops, because those discrepancies can come back and hurt you later. So going back to let's say you get hired on as counsel. So step 1, get the entire I guess narrative, or get the entire, what was going through your mind when you pulled that trigger.
Yep.
What was happening? What did you hear when you pulled the trigger? What did you see? What did the guy tell you? What did other,
And right now, because your client's talking to you, the lawyer, everything's still kind of fluid, right? You have an opportunity to shape those recollections.
Yeah.
Again, not lying, but shaping, because you can ask, well, were you thinking about this, or were you thinking about this, or were you perceiving that? And so you're kind of shaping your client's recollection of the narrative in a way that's favorable. The biggest trouble I have when I consult on cases is when I'm brought on late and I'm stuck with the facts of the record, and there's nothing I can do. I don't have a time machine. I don't get to go back and change what someone said to the cops or what's in the official record. I have to work with what they give me. I'd rather be there, an hour after it happened, and then I can help. Creates the wrong word, but structure that narrative. Formulate
the arguments in a strategic manner, which is, obviously very important, because, we're talking about something, where one small little fact can change everything. And it's very important to make sure every detail is there, that, because anything can change.
It's the difference between no crime was committed and 60 years in prison.
It's that, yeah.
I mean, those are the stakes.
Yeah. And it's really, so he got a $1.25 million bail. I know he has a GoFundMe. I think he has enough to probably post the bail, because I think he's got to post 10% or whatever.
I doubt it.
Well, sorry.
No, it's going to be, it'll be more than, so a normal bail, you're right, it's 10%. But when the exposure for the bail bondsman is this high, they want 10% as their fee. Yeah. And then they want collateral for the rest.
Gotcha.
So
put up a house or something.
They won't take your house, but they'll ask you to put up your house. Right?
Gotcha. Okay, so
by the way, this is not an insane, it's a very high bond. I've seen it before in murder cases, attempted murder cases. I know one of the gripe that's in the community is that they see black suspects commit worse crimes, not attempted murder, but literally murder, literally assassination, and get like a $200,000 bail. That's one of the legitimate grievances I talked about at the start of our show today. This is a real concern. This should not be happening. But it does happen. George Zimmerman had a multi-million-dollar bond. Kyle Rittenhouse had a multi-million-dollar bond. Is it because they're white guys? Yeah, maybe because it's a politically charged event. In Zimmerman's case, a racially charged event. Yeah, is that right? No, it's not right. But they're allowed to do this. Frankly, I would expect. I think maybe. So this is a 2-stage process right now for Chud. So right now what he's got is bond. There's bond and there's bail. So bail is often a kind of technical process where reports are filed, like, is this guy a flight risk? Does he have bonds to the community? There's an examination of facts that goes into bail. Mm-hmm. But before you get to bail, because bail takes an arraignment, which is normally a few days later, post-arrest. Bond is something you might get right away. So it's possible they gave him a $1.25 million bond, and then when they get to bail and they have more facts in the record, they'll reduce the bail. I don't think Chud's getting out on a $1.25 million. I don't think he has the resources to do it.
His GoFundMe has like 130, 140K in there. He has a GoFundMe.
It's not enough. That's enough for the 10% for the bail bondsman, but it's not enough.
How much do you think he's going to need?
Is not
like total
half the remainder.
Okay,
so $500,000 in collateral. He doesn't have to lose it.
Yeah.
So again, when you pay a bail bondsman, you put up the 10%. The bail bondsman keeps that 10%. You never get it back. That's his fee.
Yep.
If he had 1.25 million himself, he could put it all up, cover his own bond, and then as long as he shows up to court, he ends up getting it back.
Yeah.
100%. So what I expect would happen here is he'd have to put up 10%, 125 grand that he loses to the bail bondsman, and then the bailsman is going to say, but I want collateral for $500,000 that's left over.
Yeah, gotcha.
So do you have a $500,000 house, or do you have a house with $500,000 in equity? I mean, do you have a $500,000 in resources that can be collateral that I can seize if you run?
Gotcha. Okay.
And not many people have that.
Yeah.
So
no,
I don't know if Chud does or not, but I would be surprised.
Okay. So we went over. So if you were hired as the attorney,
that could be his give, send, go, or whatever he's doing. I mean, if he raises another $500,000, he could put that up as collateral
by himself. Oh no, to the bail bondsman. Yeah.
To the bail bondsman, right?
Okay. So we went through. So if you were the attorney, first 24 to 72 hours, you're getting all the facts from him based on what was going on. Now here's my question. He tells you everything. How are you going to convey that to the court? And then at what stage are you going to convey that to the court? Are we talking preliminary hearing you're going to go into and do this? Are we talking post-indictment? When are you going to present these facts, this self-defense case that your client has presented you? When do you present it to the prosecution? Pre-grand jury, after grand jury, preliminary hearing? What do you think? What's the best way to go about it?
That's a great question. So there's a lot of stages at which you can make factual arguments to the court. You could make them at the bail hearing, saying, Your Honor, these are the facts that are favorable to my client. That should reduce the bail. But remember, everything you say, the prosecutor's hearing too. So if you're kind of giving away your strategy, your argument that you want to present at trial, you're giving it to the prosecutor now. And the prosecutor hears it and it's like, oh crap, we have to find a counter argument to that. So often you don't want to reveal that to the prosecutor any earlier than you have to. Now, many states have self-defense immunity statutes. And a self-defense immunity statute is an opportunity. So normally in a self-defense case, the only way to have self-defense adjudicated, like this was self-defense, it was not a crime, is to go through a full-blown trial. But some states have self-defense immunity. Florida has it. A bunch of other states have it.
Does Tennessee
What
have it too, or
self-defense
no?
immunity allows, what's that?
Does Tennessee have it too, or no?
I can check. I'll pull it up while I'm talking. It probably does because it's a conservative state, but I can check for sure. I keep a record
because
of this
I
stuff.
do think
Let's
it's important to realize that he was released at the scene, then he got arrested several hours later. So he was free for a little bit until they came and made the arrest. But I think the arrest was more political than anything. Because
was he in the hospital?
Yeah.
I mean, he had a gunshot wound.
Yeah, he did go to the hospital. Yeah,
they knew where he was. Is what I'm saying.
Yeah.
They weren't worried about being able to find him.
Yeah.
So Tennessee has self-defense immunity. The way self-defense immunity works is it gives you an opportunity to have your use of force be determined to be lawful self-defense without having to go through a trial. You can do it at a pretrial hearing. And that's huge because the trial can easily be hundreds of thousands of dollars in legal expense, and you might lose. And if you lose, you go to prison for the rest of your life, right? So the ability to do this at a pretrial hearing, which is not free, but it's only a few $1,000s. And if you lose, you still get to make your same argument at trial. It's not a game ender for you. And basically what it is, it's like a mini trial before the trial. So there's no jury, but it's before the judge. And you get to argue to the judge, hey, these are the facts that support my claim of self-defense. And if the judge is like, yeah, that sounds good to me, he can grant you immunity from prosecution and you never go to trial.
So here's my question. When does this pretrial happen? Because obviously we got the arrest. Looks to me like they made a probable cause arrest. I don't even know if they filed a criminal complaint. Does this happen after they make their PC arrest? Does this come before the preliminary hearing, during the preliminary hearing, post grand jury indictment?
After all that, it's the last thing that would happen before you actually go to trial.
Okay, all right. So you would actually still go through the entire arrest
All
process.
the discovery is done, right? Everything is done except the actual trial. And so basically, just before you go to trial, you have the option of saying, Your Honor, we'd like a mini trial before you impanel a jury, before we do the whole full-blown thing. And I want a day or two to explain why this is self-defense, and then the prosecution can argue against that. And if you convince the judge it was self-defense, you never have to go to trial. You're immunized from prosecution. The trouble is, a lot of defense lawyers don't like to do this because you're exposing your entire strategy to the prosecution at this mini trial before the trial. And if you don't win immunity, you are going to trial, and now the prosecution knows every argument you're going to make. Right? They're not surprised, and they can prepare counter arguments to it, right? Counter strategies to it. I still think it's nice to have self-defense immunity as a option. I just because of the tremendous cost and risk of the trial itself, it often works, self-defense immunity, but that is the risk you're taking. You're putting all your cards on the table.
Is it basically a bench trial? Does it essentially, is it the judge makes
It's like a mini trial.
Yeah, but it's
and it's final.
And the judge makes the decision.
The judge, there's no jury. The judge makes the call, right?
Wow. Okay. So
but if you lose, you get to argue it again to a jury.
Yeah. Okay.
So you haven't lost anything in terms of your legal options, but what you've lost is you don't have the option to surprise the prosecution at trial anymore. You've shown everything.
So, I mean, and self-defense is kind of one of these cases that's a bit different because this is like one of the few times where, you know, putting your guy on the stand might make a little bit of sense. Like, do you think Chud's going to have to go to take the stand?
It can make a lot of sense.
Yeah.
In self-defense cases, it's often the case that the best source of evidence that supports self-defense comes from the mouth of the defender. What they were feeling, what they were thinking, why they did what they did. If they're not testifying, how do you get that into evidence?
That's what I was going to say.
I mean, there's really no other source. It can be very difficult. So often you want to, normally, of course, a criminal defense attorney never wants to put their client on the stand. But in a self-defense case, it's like, hey, listen, there's a lot of important stuff we want the jury to know that can only come from your mouth. That's why Kyle Rittenhouse took the stand, right? George Zimmerman didn't take the witness stand, but the only reason he didn't was because the police had him do a number of walkthroughs of the crime scene where they videotaped him, and then the state introduced all the videotapes. So basically, George Zimmerman got to testify, like virtually, without having to take the witness stand and expose himself to cross-examination. Kyle Rittenhouse had to do 3 hours of cross-examination. And that guy was, that kid, and I know Kyle Rittenhouse, by the way, he's one of the nicest people you'll ever meet, but that kid was on the witness stand for 3 grueling, torturous hours. I mean, we all saw him break down, right, crying on the witness stand. And that kid was clean as a whistle.
Yeah.
Imagine how many hours they would keep Chud the Builder on the witness stand, showing him video after video. Was this you calling this black guy the N-word? Yeah? Okay, how about now? Was this you? Also this guy? Also this 150th black guy you're calling the N-word? We just want to make sure this was you, right? Oh my God, it could be endless.
Yeah, no, and that's, yeah, they could do that. Hopefully the good defense attorney is going to object and make sure, they're able to redirect or whatever, but on redirect. So like, okay, so 24 to 72 hours, get the information you need. Obviously, no more statements to the police. Anything else you would do if you were his lawyer as far as like preparing for going? Would you in this situation, would you go ahead and do the mini trial, the pre-trial with this defense immunity that the state offers?
I probably wouldn't, because I think it's such a politically, racially charged event. Remember, you're asking a judge to say, this guy can't be tried in front of a jury.
Yeah.
That's what the immunity hearing is. And so you're asking the judge to put a lot of skin in the game for a white dude who calls black people the N-word to their face.
He doesn't want that either.
I just don't see a judge doing that. Because the judge can just say, nah, I don't buy it. You go in front of a jury. Let the jury decide. Just pass the buck is what I would expect to happen.
So in this situation with Chud, for him to be able to, establish all the, self-defense claims that he has, all the things that we discussed that might have been aggravating factors, he's basically going to have to do it at trial, is what you're saying. He won't be able to have an opportunity really to do this in any other manner?
Well, there are things he can do that can be important pre-trial. I don't know how nuts and bolts. I don't want to bore the audience.
No. My audience is higher IQ. They love this stuff, so you're good. You can go into the nuts and bolts.
So a big concern with Chud, of course, is this question of provocation, right? Did he provoke the fight? And normally, the defendant in a self-defense case can only bring into evidence things he knew about his attacker. I had personal knowledge this guy had a long criminal record, right? If you didn't know it, you can't bring it into evidence. But there is an exception. The exception is if the prosecutor attacks your claim of self-defense on that element of innocence, that you were the aggressor or you were the provoker. That opens the door for you to introduce evidence about the other guy that you did not know at the time. Because what the prosecution has done by attacking that element
that's crazy. So one more so because this kind of goes against what we discussed before. If you don't know certain things, you can't bring it later.
You can't get it in. Right. So this is an exception to that general rule.
Okay, one more time with that one. So
we mentioned the 5 elements of self-defense,
yes.
right? One of them is innocence. You started the fight, basically, either because you were the initial aggressor or you provoked her. Well, that raises a question for the jury. Well, who started the fight? So what becomes relevant is, well, who between these two guys was more likely to have started the fight? That opens a door to admit evidence that the other guy has a history of violence, even if you didn't know about it, because that's relevant to whether or not it was more likely that he started the fight. Gotcha. So what I would do if I were Chud's defense attorneys, what I would say, listen, I just want you guys to know, if you're planning to attack my client on this issue of provocation, I'm going to bring in that other guy's entire criminal history because you'll have opened the door to doing that. And that can prevent the prosecution from bringing up the provocation issue in the first place because they don't want that other guy's criminal history coming into the record.
Wow. That's a bombshell. That's a bombshell. Because in this situation...
So you tell him, listen, you can accuse my client of provoking if you want, but if you do that, I'm going to get that other guy's entire criminal history. The fact that he tried to burn down the building his ex-wife is in, that's all coming in. And otherwise it wouldn't.
Yeah. Yeah, because I remember even
so a
when
lot
I was
of times prosecutors will say, oh, shit, well, then we'll attack him on other things. We'll say he went to the gun too soon. We'll say he was generally being unreasonable, but we're not going to bring up the provocation issue, which would be a huge win for Chud. That's obviously a big point of vulnerability.
I would argue that's like the linchpin is the provocation, because I think a big reason why they went so hard at this guy and came after him is because, well, this guy walks around and provokes black people all day, right? This is what he does.
I think that's right.
This is his shtick. He provokes. He starts the fight. It was just a matter of time. He's trying to do this for clicks and for views, etc. And then even in this situation, right, where they're gonna, because the default assumption by everybody is he provoked this fight. So even with him disengaging, they still assume now he provoked the fight or whatever. But what you're saying is, if the prosecution intends to bring it in, which we know they're going to try to, of course, that's going to be probably the cornerstone of their argument, is that this guy's a provocateur for clicks. The defense attorney can counter and say, okay, you want to play that game? We will bring in your star witness and destroy his credibility.
Even if our client didn't know anything about him.
That's actually, wow. That's huge, man. Because, some prosecutors might say, damn, my star witness is kind of a piece of shit. Like the guy has a criminal history. Right. There's the face, because I saw social media posts where he literally was saying like, yeah, I'm going to get Chud. I'm going to get rid of him, blah, blah. So now, because the key is, did Chud know this? Let's say you're his attorney. He tells you, no, I honestly, sorry, Andrew, I didn't know about this stuff, that he threatened me. That might explain why he was saying, I'm going to get you, blah, blah, blah. But I didn't know that he had said this stuff about me on Facebook. But now the prosecutor says, well, we're going to introduce that he provokes people. Then you could counter, oh, well, you know what? I know that your client, or not your client, I know your star witness had made posts days before threatening that he was going to find him and kill him. And it doesn't matter that Chud didn't know because now I'm going to use this. And that might scare them from using provocation.
Right, exactly. So, and the problem is
Chud's
lawyers would need to know this.
He needs to hire you. Wow.
Most lawyers don't know this. Most lawyers, I talk to criminal defense lawyers.
You just killed their case, Andrew.
30-year careers. And most of their self-defense cases are bad guy cases of self-defense. And so they've only had 3 or 4 good guy cases of self-defense in their career, like once every 8 years. You don't get good at it if you do it once every 8 years. They don't just know that they don't know this stuff because they've never encountered it.
I would say,
but that's why people hire me.
No. I mean, dude, you know, this is like, that's unbelievable. Like, and this is the importance of hiring a lawyer that I would argue right now, what you just said, you just destroyed the prosecution's main argument that they're going to use. Because I think a whole reason why they went after him, why they made the arrest, etc. Obviously, it's from a cover your own ass
from their perspective.
From their perspective.
Right. Yep.
But I would argue that what they're also going to say is that, you know, this guy's a danger community, he provokes, blah blah blah. But but this guy that he got into a fight with is a piece of shit. So that might disarm the prosecution's provocation argument, which I would argue is literally the underlying factor as to what they're going to go after.
Now they have to make a decision, right? Do they want to give up that line of argument, or they want to go forward? And then the jury gets to hear all that stuff about their star witness on cross-examination. Isn't it true you said this? Isn't it true you did that? And it has an effect of deflating the histrionics of the defendant, of Chud the Builder, right? Sure, he says crazy shit, but their star witness says crazy shit too. Maybe it's a wash.
Would him admitting that he has PTSD work in Chud's favor?
I would think so. It would to me. So if someone says, "Listen, I'm gonna punch you in the face," and I'm crazy.
Yeah, yeah. You better not say chimp out to me, or else I got PTSD. I think that's what something along the lines like that was said to him.
On the other hand, it can go the other way, right? If someone says, "Listen, I'm crazy," and if you say, let's say it's I'll make up a word, lemon, right? If you say the word lemon to me, I'm gonna punch you, and then you say lemon, and you get a punch. Didn't you provoke that punch? I mean,
yeah.
You know, the other person's not acting rationally, but you knew when you said that word that a punch was going to be incoming. Yeah. You kind of triggered it. And right? Then, I mean, what would a reasonable person do? I wouldn't say lemon.
Yeah. Yeah. Or let's assume to play devil's advocate, let's say he does punch him, right? And he continues to punch him after that. Now I think we've established, you know,
sure, the sustained use of force that may be deadly force. By the way, the saying of lemon doesn't justify the punch. The punch doesn't become lawful. It's still an unlawful punch.
Yeah.
But you can't say you were surprised that the punch happened.
Yeah.
Right? An argument can be made that you provoked that unlawful punch.
That's what I was going to say. So he punches him once, you can't pull the gun out and shoot him. But if he keeps punching you, you can argue that that's an aggravating factor because now it went beyond just one punch. Now he's punching you more and more. You can make the argument that, oh, well,
yeah, I mean, again, small changes in facts make big changes in legal outcome, right? If the guy says, listen, I have PTSD, and every time I punch someone, I kill them, then the punch may be, you know, say, well, shit, I can't afford to take that punch. He kills everyone he punches. It becomes a deadly force threat. But again, this is why it's important to have as atomic an understanding of the facts as we can, which we don't really have now.
Yeah, apparently this guy was a veteran too, so he served in the military, which, you know, maybe Chud's defense can argue, oh, well, he knows how to kill people. You know.
That's what I would argue that, even though, of course, most people in the military.
It would be weak, but like,
you know, the military, listen, God bless the military, but there's a lot of people in the military who are, you know, clerks and cooks and nurses. And, you know, it's not like everyone's the pointy end of the spear.
Of course, of course.
But certainly if I were the defense lawyer, I'd say this person has military training.
Yep.
Exceptionally lethal.
Yep. No, I mean, that's I think Chud needs to hire you, man, at this point, because you know, I think that right there is like I think you've just disarmed one of the big arguments that the prosecution is going to use, which I think they're going to use the provocation angle to attack him.
And one thing I can guarantee you, because I've made this argument, one thing I can guarantee you is the prosecution is completely unaware that they're vulnerable on this. They're completely unaware. They would hear that argument in court in front of a judge and they'd be like, oh shit.
Yeah, no, that's very interesting. What is the name of that? What's that? What's the, I guess, legal term for you being able to bring in the star witness's background and damage their credibility?
It's simply that you've made a material fact of the case who started the fight. And if it's a question of who started the fight, then it becomes, you know, the jury's allowed to consider all evidence that's relevant to a question they have to answer. And if the question is who started the fight, well, then people's violent prior history becomes relevant to that question. That's different than you went to the gun too early, right? If that was the line of attack, if proportionality is what the prosecution's attacking, well, that's all on you. That has nothing to do with the other party. But if the question is who's more likely to have started this fight, then each party's criminal history is relevant.
So And before, I know you got to probably have to go here soon, but this has been awesome. So let's go through, with Chud's case, let's kind of go through the 5 things, and we can kind of go through what he's strong on and what he's weak on with the 5 circumstances when it comes to self-defense for his particular case based off what we know now.
Right. So to remind, I'm sure we have a completely different audience now.
Yeah, you could go ahead and go through it one more time.
So for any claim of self-defense, there's 5 elements that you need to have that are subject to attack by a prosecutor. And if he disproves any one of them, self-defense goes away and you've basically confessed to the crime. It's an easy conviction. And those 5 elements are innocence, whether or not you were the initial aggressor or provoked the fight. If you were, you lose innocence, you lose self-defense. Imminence, the threat you're defending yourself against is either actually happening or immediately about to happen. I can send you something, man. You don't have to.
No.
I'll send you a PDF.
I like to write it down because it helps me remember it more.
Or you could get the book, man.
Yeah.
I thought I gave you the book.
You did, but then some bimbo here cleaned up my spot, and I was literally looking for it. That's why we started a little bit later. I was trying to find it. Innocence was the next one is imminence, right?
Imminence, that the threat you're defending yourself is either actually happening, you're getting beat, or it's about to happen. The fist is pulled back, the gun is being drawn. It can't be a past threat that's over or a future threat that may never happen. Then we have proportionality. You can only use deadly defensive force like a gun or a knife if you're facing a deadly force threat. If you're only facing a non-deadly force threat, you can only use non-deadly force in self-defense. Avoidance has to do with whether or not you have a legal duty to retreat before you can use force in self-defense. And then reasonableness. Did you genuinely believe in the need to act in self-defense? And would a hypothetical, reasonable, and prudent person in the same circumstances have shared that belief? In other words, your belief is not enough. It can't be speculative. It can't be the result of panic or bare fear. It has to be a reasoned belief that a reasonable and prudent person would share.
Someone in the chat said he's not a lawyer. Hey, retard, he is a lawyer. He's not a fucking consultant. Other people consult with him because he's the expert of self-defense, idiots. He is a fucking lawyer. Retards. Do not say that shit in my chat. You'll get banned. So I got, sorry.
I don't care what people say about me.
Because but I'm not going to let these idiots come in and lie on you. Like, you're a lawyer and people literally one of the best in the country, and people consult with you. So fuck that idiot. So innocence, eminence, proportionality, avoidance, and reasonableness are the 5 factors.
Right. So the big vulnerabilities for Chud here are innocence, whether or not he provoked a confrontation. I don't know if that's true or not, but if he did, that would lose him innocence, would lose him self-defense. Another one, arguably, is proportionality. Did he go to the gun too soon in the context of a fist fight? That's a very fact-specific question. We'd have to know a lot more about what happened.
What was said, what was done, people were there, what was being, so that one is probably the most sensitive, probably.
Fights are dynamic, as we talked about, right?
Yeah.
So an instant change, right? Maybe that guy got his hand on his throat. Maybe an arm went around his neck. Maybe his head hit the sidewalk. Suddenly, everything changes and going to the gun is appropriate.
Yep.
When an instant before it wasn't. That's how fact-specific it is. And then there's the 5th element, the final element is reasonableness. And that's so general, but it carries so much weight. So if you look at Tennessee's self-defense statute or any state's self-defense statute, you'll see the word reasonable, reasonableness, some variation of it everywhere. Sometimes it happens more than once in a single sentence. And that just reflects the weight that this element gets in self-defense law. And the trouble with reasonableness is it's a judgment call that's being made by other people after the fact, right? So whatever you thought was reasonable in the moment, yeah, of course, I shot that guy. I thought it was reasonable, right? But that doesn't determine your legal fate. That doesn't determine whether or not you get convicted. What determines whether or not you get convicted is whether the cops and the prosecutor and the judge, and most important, the jury, if they think it was reasonable. You could think it was 100% reasonable, but if the jury doesn't agree, convicted you are, and off to prison you go. And you have, when you're in the moment you're defending yourself, you don't know who your jury is.
Is this why it's so critical? Is this why it's so critical that a lot of the times the defendant has to take the stand because only they can describe what was going through their mind, what they were experiencing, what they were smelling, what they were seeing, what was going through their mind, because
why it was reasonable.
Yeah, because like you said, everything hinges upon reasonableness, but obviously, there's only one person that can take you through exactly what's going through their mind at the same time. I saw someone out of the corner. I say, kill him, get him, get him. I smelled gunpowder. I saw him reaching like this, and I saw what looked like a knife sheath, whatever. Like, all of these things are intimate details that, no one else is really going to be able to recall. But if you recall it and you tell them this is what was going on, then they can say, if I was in your shoes, I would have shot too. And I think that's the goal here, is you need to be able to convince them that they would do the same thing if they were there.
And think about a jury. Right, jury, they're just normal people. They're just normal human beings, right? And they're going to think to themselves, all right, you're admitting, right? You shot and killed that dude, or in Chud's case, you shot that guy in the belly and he lived. All right, maybe that's lawful. Maybe that's self-defense. Maybe that's not a crime. But we're going to make you talk us into it. You have to convince us of that. And if you're not willing to take the stand and explain to us why you shot that guy in the belly, absent a good explanation, that's just a crime.
Yeah.
But if you're Chud, how do you take the witness stand and get all those videos put into evidence? I mean, there's a benefit to living a clean life.
Yeah,
right?
There is.
If you're ever accused of a crime and you have to take the witness stand, you don't have a lot of baggage coming with you. Chud doesn't have that.
Shit, man. So, would you put him on the stand if you were his attorney at this point? How would you go about getting his testimony in where he actually felt in fear for his life? How would you go? Because this would be a very difficult case to handle.
If the client's not willing to take the stand, you have to stitch together eyewitness statements, things in the medical examiner's report, and then in closing argument, you have to stitch all that together and say, listen, stitching all this together, any reasonable person would have been in fear for their life. But it's not the same for the jury as hearing it from the defendant. And there's a reason when the defendant testifies, it's invariably because in a criminal trial, the prosecution presents their case first.
Yep.
And then they rest. And then the defense presents their case second. And if the defendant takes the witness stand, it's almost invariably the last witness of the defense, meaning the last witness of the trial. And part of that is you want it to be the most compelling testimony for the jury. You want it to be the last thing they hear before they get their jury instructions and go into deliberations. But part of it also for the defense is they don't want to do it. They don't want to put their defendant on the stand. So they're delaying as long as possible to make that call.
Okay, yeah. So it could be a last minute, split second. Okay.
It's a last minute decision.
It can be. Okay. So fair. So I guess with the facts that you have now, you probably wouldn't put Chud on the stand. But if you were his attorney,
it depends on how the trial goes.
There you go. Okay.
Every word in the courtroom, you're looking at the jury, you're looking at their demeanor, at their expressions. And even those of us who follow these trials when they're live streamed from the courts, you never get to see the jury, right? That's something we don't get to see if we're not in the courtroom. But the lawyers get to see it. And they're getting a sense of, right, which jurors are affected by which arguments and what do we want to emphasize and not emphasize. They're developing that over the entire course because the lawyer's exposure to the jury is only in the courtroom, right? They've never seen these people before. So you're kind of observing their reactions and you're watching what's happening. And at the last moment, before the jury's instructed, the judge is going to ask one last time, counsel, do you want your client to testify? Because we're about to wrap this up. And then the counsel has to say either we rest or, yeah, we're going to put him on the stand.
Okay.
It's a hard decision to make because you never really know. Even with completely innocent clients, you don't know. The trouble is once you put him on the witness stand, he's off the leash. You have no idea what stupid shit is going to come out of his mouth once he's on a witness stand. And the prosecutor is there to goad him, to taunt him. That's what they did with Rittenhouse, right? To shame him, to make him angry, to make him explode and say something stupid on the witness stand that'll have an impact with the jury that'll lean them towards conviction. It's very dangerous, and good prosecutors are extremely skilled at doing this. So it's a very high-risk strategy to put your client on the witness stand. But in a self-defense case, sometimes how else are you going to get the evidence in?
Yeah, man. And in a trial, obviously, hearsay is not admissible. It has to be the actual witness to come in and testify. So fair enough. No, man. Okay, so I guess in closing here, so what are your thoughts on the case? Do you think he can be saved? Do you think he's cooked? Do you think there's a chance that he doesn't get cooked? What are your general thoughts?
I mean, I don't have enough facts, right? I can imagine facts that would be very consistent with self-defense. It would look like a robust case of self-defense. And a lot of those facts are amorphous. Like we talked about, it depends on what his lawyers are pinning down right now, as facts. And I can imagine a scenario in which a jury will be very easy to convince that this guy, given his history, provoked his confrontation, and they just don't like him. They don't like him. He's outside their comfort window. He's an a-hole, and he provoked a confrontation in which he had to shoot someone, and that's on him, and he ought to go to prison.
Yeah. Man, okay. So I think someone from Chud's team needs to reach out to you, man. And sooner than later. I think the bombshell you dropped earlier with the provocation was insane. Because I predict that's going to be the prosecution's main argument is this guy provokes, he's a provocateur, he's doing it for clicks. And if they brought in their star witness, who that guy's a scumbag himself, and then we have all this other evidence where he was literally threatening to hurt Chud and everything else like that. Even if Chud didn't know that prior, getting that in would be really powerful, I think, at least to say that, like, look, now this makes more sense why he might have closed the distance and attacked them, and Chud was acting in self-defense. So basically, you're muddying up the star witness and the defendant at the same time, but the prosecution might not want their witness being muddied up that way.
Yeah.
Because the burden is on them, not the defense.
Their case being, they don't care about the witness, but
yeah. That's what I mean, yeah.
It would complicate their case.
Yeah.
Right? And one last thing I want to mention before we go. A lot of people are treating this like a First Amendment case. Like, well, you're allowed, it's not a crime to say the N-word, and it's not a crime to say the N-word. But this is not a First Amendment case. That's not what this is about.
Yeah.
Chud is not charged with saying bad words. He's charged with shooting somebody in the belly. And in the context of shooting someone in the belly, if you say words that provoke a confrontation, you can lose self-defense. It's like if you walk into a bank and say, I've got a bomb strapped to my body, give me all the money. Well, you're just saying words, right? But that doesn't mean you're not committing a bank robbery. You don't get a free pass because words were involved. It doesn't become a First Amendment case. There's nothing about this that is a First Amendment case.
Yeah, no, I agree. It's, I know that's what he says, like he's trying to bring free speech back. But yeah, this is going to definitely be, based on the factors you had, the innocence, the imminence, the innocence, the avoidance, which would avoidance even play into this? It wouldn't, right? Because it's Tennessee, stand your ground?
No, it can, because normally in Tennessee, it's a stand your ground state. So in otherwise lawful self-defense, if everything else is fine, you don't have a legal duty to retreat. But in Tennessee, if you provoked a confrontation, you lose self-defense unless you withdraw from the confrontation and communicate your withdrawal to the other party. You've essentially reacquired a legal duty to retreat that you would not otherwise have had.
Yeah, so him disengaging is going to be huge if that actually happened based on what these people are saying. Did he actually walk away and say, I hope your day gets better, God bless, and he was 70 to 100 yards away? If he actually did that, that obviously significantly increases the strength of his self-defense.
If he did that, by the way, when you're doing that, you have to be withdrawing in good faith. If he's walking away and he's still shit-talking the whole time he's walking away, he's still using the N-word and all the chimping out stuff, if he's saying that while he's walking away, he's not really disengaging from the fight. He's still provoking.
Oh, okay.
So you get rewarded because you're trying to genuinely prevent the fight from happening. You're trying to genuinely de-escalate. If you're walking away and talking shit, you're not de-escalating anything. You're walking away like the champion. Gotcha.
And that would not be even arguable. You'd pretty much lose that ability to refresh your self-defense.
But it's not compelling anymore.
Okay. Fair enough.
Well, what you want the argument to be is, listen, even if I provoked that guy, I had a bad day, I was out of my mind, it was a mistake, but I did genuinely try to stop the fight and walk away. I did not want the fight to happen. It needs to be as clean as possible.
Yeah. To make it easier for the lawyer to argue. Because anything is arguable, but it's like,
Right.
Obviously let's make it as simple as possible so that we can get around this hurdle, especially with that situation. But no, I mean, that was some fantastic legal analysis, and I really appreciate, the impartiality.
Hey, before we go, can we plug the book one more time?
Absolutely, man. I'm bringing it up on screen right now as you speak. Go ahead. Talk about it.
If you like this self-defense law stuff in plain English, we give this book away for free. It's on Amazon, by the way. You can check out the reviews there. It's 5-star rated, 1,500 reviews, I think. But don't buy it on Amazon. They'll charge you $20 or $25 for the book, plus shipping and handling. We give you the book for free. We only ask that you cover the cost of shipping the book to you. You can get the book for free at lawofselfdefense.com/free book. Free book, easy enough to remember. lawofselfdefense.com/free book.
Mod, spam that in the chat for me, please. Let's make sure we hook up Andrew. And and I got it up on screen here. They can see the book. Guys, reading a book like this might save your life, dude. Like, honestly. Let me see if there's any last minute questions here for you, Andrew. Let me see here. Okay, here we go. Olympian13 says, according to Grok and general data, Chud has received hundreds of death threats online. Could this be one way that he could justify a fear for his life from the attack, and that is the reason he pulled the gun to defend himself?
It could be. Again, the more specific the threat, the more relevant it is in legal terms. So if he got a threat from this guy, that would be the most powerful evidence, right? Oh, I got a threat from this guy. Then this guy approaches me on the street. He threatened to kill me. That's why I went to the gun. That's very compelling. I've gotten a threat from a bunch of black people, and this guy happened to be a black person. That's much more general. That's much less compelling. I would still make the argument, but it's much less compelling.
Okay, Fried Pickle says, to all the people, racial epithets do not constitute fighting words per Supreme Court precedent, Terminilio versus Chicago in 1949.
People don't know what fighting words mean. So people think fighting words means that if you say the words, someone's allowed to punch you. That's not what it means. It has nothing to do with that. Fighting words in Supreme Court jurisprudence has to do with, if you say words, can you be criminally prosecuted for your words? It doesn't mean, can someone else lawfully punch you? It just means you said words. Are those a crime? Can you be criminally prosecuted? And the Supreme Court has said, well, there are some words that can be criminally prosecuted. But it's a very narrow category. It's how you get to like disorderly conduct. It has to be words that are said very directly to another specific person, in their face, representing an imminent threat of harm, likely to incite an immediate violent response. That can be prosecuted as disorderly conduct. That's what fighting words means. Can you be prosecuted for the words you're saying? It has nothing to do with this notion of, if I say these words, someone then is lawfully justified in punching me in the face. It's got nothing to do with that.
We got Jacoby here says, is this book also for self-defense in Europe? You guys might be cooked in Europe. I don't know.
No, I'm sorry. It's only American self-defense law.
Yeah.
Sorry. I don't know anything about European self-defense law.
And obviously, you know,
America and every territory. So DC, Guam, Samoa, Puerto Rico, where American law applies. You people in Europe are, sorry.
You guys are cooked. You guys are cooked. You can't even have guns, man. You guys are cooked in a lot of places. But no, Andrew, thank you so much for coming on, man. Guys, get his book. It's completely free. I put the link in the chat for you guys. It's also pinned. It's also at the top of the description. So get the book, man. Go check him out. That was a fantastic discussion. Thank you so much for answering the questions, Andrew. It's always good talking to you.
All right, man. Pleasure to be here. I'm happy to be on anytime. Look forward to seeing you in person in Miami again.
Yeah, absolutely. And, you know, if new facts come out, man, we'll just jump on and discuss it, because I'm sure there's going to be, I assume, has a criminal complaint or any legal document been filed in this thing yet, or no?
Yeah, I think it was filed today, but I haven't been able to find it in public sources yet. It's not uncommon in local state jurisdictions, especially small counties like this, for it to take a while to be online. But I'll be following this case at length, because, as you say, we're going to learn new facts ongoing, and small changes in facts lead to big changes in legal outcomes. So
absolutely,
I don't care about Chud personally. Again, he's not a friend of mine. He's not an enemy of mine. For me, this is just completely emotionless legal analysis. But the legal analysis becomes a lot more robust the more evidence you have to work with. So yeah. I'd love to see more video. I'd love to see more witness statements, stuff under oath, you know, where someone's identified and you can evaluate the credibility, not just anonymous X stuff. But we'll get a much more robust sense of where Chud stands the more evidence we have.
All right. Andrew, thank you so much for coming on the show. Guys, go check him out. He's also on YouTube, has his own YouTube channel. You live stream, don't you live stream every day at like a certain time? At like
on social media and X and YouTube, people can, and locals and Rumble, people can find me at The Branca Show.
Okay.
At The Branca Show.
There you go. Check him out, guys. The Branca Show, go check him out. Thank you so much for coming on, Andrew. Appreciate it, man.
All right, man. Have a good night, dude.
All right, later, brother. Bye. Okay. Andrew. Andrew, I hope you guys enjoyed that. You know, a lot of the similar things I've been telling you guys for a minute when it comes to self-defense in America. It's like I got to bring a lawyer on for all the smooth-brained idiots, you know, that don't understand use of force. But there were definitely some interesting things. That's a huge bombshell that the provocation can actually be judo flipped on the prosecution. So that's kind of crazy. Guys, we're going to go ahead and get off YouTube now. We're going to go over to Kick, and we're going to cover some news, cover some other current events. Iran war. There's some new news with David, Murdoch case. We got some things that we're going to talk about. We're going to be on for at least another 2 hours. We got Fresh and Fit After Hours coming at like 11. So, guys, come on over to kick.com/MyronGainsX. Now we're going to do some, we're going to switch up. We're going to cover some true crime, some Redpill stuff, a lot of stuff to yap about. So come on over, guys. I am ending the YouTube stream now. So come on over to kick.com/MyronGainsX. It looks like our guy Larry Wills revealed he broke up with his suit model wife. Oh, man. Well, well, well. So come on over, guys. Come on over. We're going to cover some, as usual, Red Pill a day, keeps the simple way. We're going to cover some geopolitical things, cover the news. So, yeah, come on over, guys. Come on over. Okay? Come on over to kick.com/MyronGainsX. As you guys know, I'm demonetized on YouTube. I know we got a lot of new people in here that might not be familiar with why I don't stream on YouTube like that anymore. It's just not my main platform. I just come on here just so give you guys value, let you guys know that we're live. But YouTube is not my main thing, so I'm going to get off this platform. So let's go ahead, guys. Come on over to kick.com/MyronGainsX. Come on over. I'm ending the YouTube stream now. And we are going to go on over to Kick, which is my main streaming platform. I still stream on Rumble and OSS, of course. OSS is the always home base. But Kick is where we are. And plus, guys, Kick is better than YouTube, bro. There's no ads. There's no ads on Kick, bro. So I don't know why you guys aren't watching on Kick. Kick is 10 times better, more interactive. You can send super chats on there. So, yeah, helps the show continue going. So, yeah, YouTube going down right now, guys, okay? Come on over. We're going to cover Larry Wheels. We're going to cover some news. We're going to cover Iran. We're going to cover Russia. There's been some developments with the Russia conflict that we're going to talk about as well that aren't getting put too much in the news because of, obviously, the China summit. We're going to talk about Trump left China, I think, earlier today. So we're going to talk about all that stuff. Post-China summit, Larry Wheels being cooked, breaking up with his wife, which I saw that coming. And we're also going to talk about some developments with the Russia-Ukraine war. Huge developments that are not hitting the mainstream.